Hello, NAAIA community. Get ready to relive insightful discussions, gain fresh perspectives, and be inspired by the wealth of knowledge our community has to offer. Let's dive into another episode.
Good afternoon, everyone. I hope you all are having a meaningful Tuesday thus far. Thank you for joining us today. My name is Achilles Smith, and I serve as the Leadership Program Manager here at NAAIA. We are delighted to welcome you to our October installment of our Claims Clinic webinar series titled From Claim to Courtroom, Understanding the Litigation Journey. We are thrilled to have you with us on this beautiful Tuesday afternoon. As a reminder, we are hosting today's webinar via Zoom Events, which is a webinar platform. You have been added as a participant, meaning that your camera and microphone are not active. However, we encourage you to engage with us in the chat. Please take a moment to drop in the chat where you're joining us from today. We'd love to hear from you. Now, throughout today's webinar, feel free to use the chat to interact with fellow participants. However, if you have specific questions for our panelists, we kindly ask that you submit them in the Q&A box to help keep us and the discussion organized. Now, if you experience any technical difficulties, please use the chat function and select host and panelists only. Our team is going to do our best to assist you. If your issue is related to internet connectivity, we recommend rejoining the session to continue accessing today's valuable content. Please note that today's session is being recorded and will be available for viewing at a later date. Once again, to recap, please be sure to engage with us in the chat. Please submit questions directly in the Q&A box, and please direct any technical concerns to hosts and panelists. It is now my pleasure to introduce Ashley White, our NAAIA National Chief of Staff, for our program overview and moderator introduction.
Achilles, thank you so much for bringing me to the stage, and thank you for such an excellent, house cleaning information to get our participants ready for our exciting conversation. As Achilles mentioned, my name is Ashley White. I'm the Chief of Staff here at NAAIA, and I have the privilege of leading the programs team. Today, we will be discussing an important element in a journey of a claim. Of course, every claim has a story. Sometimes it's straightforward. A policyholder experiences a loss, an adjuster steps in, and then collaboration and clear communication are there and the issue is resolved. But some other times the story may be a little more complicated, and it may twist, it may stall, and end up in a place where no one hoped it would be, and that is inside a courtroom. For those of us in the industry, whether it is in claims, legal, leadership, the journey from a claim to a courtroom is more than just a process. It is a reflection of how we work together, how we communicate, and how we understand when people are at the center of every file. Because behind every claim is a person, someone whose life, livelihood, or business has been disrupted. And the way we navigate that journey can either build trust or destroy it. Sometimes litigation isn't just about the disagreement over facts or coverage. It's about miscommunication, assumptions, or gaps in understanding, and that can snowball into something larger. Maybe it's an email that gets misread. Maybe it's a tone on a phone call or a temperature that may change the conversation. Or maybe it's a systemic issue where bias, workload, or lack of representation, those things that quietly shape how decisions get made. So in today's session, from claims to courtroom, understanding the litigation journey, we have this opportunity to take an honest look at these moments. We'll explore what happens once counsel is engaged, where communication tends to break down, and how to strengthen the partnership between adjusters and attorneys so that we are not just reacting to conflict, but actively preventing it. We'll also take a look at how representation of who's in the room and who's not may impact how cases are understood, negotiated, and resolved. Because fairness and confidence in a process is not just on expertise, but it's on empathy and perspective, as we know. By the end of the session, I hope that we walk away with just more than lessons. I hope that we leave with the tools that we can apply as early as today and tomorrow. These tools to spot red flags early and communicate more effectively, and how to approach our work with renewed integrity and empathy. Because when we get it right, when adjusters and attorneys truly collaborate, we don't just reduce litigation, we protect something more valuable. And that's the trust of our clients, our carriers, and the communities who count on us when they are most vulnerable and when it matters the most. Our conversation today will be moderated by Jeff Chen, who is the head of claims, Ryan Specialty Underwriters. Jeff, if you'll please join me on this stage. As we await for you, I'll just continue to make a few notes about your career journey. And so prior to joining Ryan Specialty Underwriters, Jeff served as a VP of claims at a regional carrier where he led several departments, coverage, compliance, and litigation. Jeff has been a titan for many headline organizations here in the insurance industry. He began his professional career as an attorney in New York, specializing in medical malpractice defense. So with Jeff's vast knowledge and experience, I'm sure this is going to be an amazing conversation. Jeff, thank you so much for joining us today. I will leave it to you.
Thank you so much, Ashley. It is absolutely a pleasure to be here with all of you. I see everybody populating the chat with where they're from, so I have to say that I'm Central Jersey. So Jersey has to represent, and I see that Rajiv is also representing Jersey. Rajiv, always a pleasure to see you, my friend. We are very excited about the conversation that we're going to have today about the litigation context of claims. As a reminder, please feel free to drop your questions in the Q&A. Let's avoid putting them in the chat because it's harder for me to monitor several screens. I'm old. It's hard for my eyes to see everything. So if you could drop it in the Q&A, we will take a look at them and we will escalate them and try to get all of your questions answered. And with me today are Gina and Tracee, and I'm going to start by turning it over to Gina so she can introduce herself.
Well, first of all, good afternoon, NAAIA family and visitors. My name is Gina Jacobs, and I'm a partner here at Hamilton, Miller, and Birthisel in the Sunshine State of Florida. Thanks again for the invitation, and just kind of a little bit about me. I actually was a claims adjuster before I went to law school, so I really love the fact that we're talking about claims and the journey to the courtroom. Again, before becoming an attorney, I was an adjuster for different third-party administrators and carriers, and in my capacity as an attorney, I lead a great team of trial attorneys here in Florida practicing workers' compensation, as well as general liability and some workers' compensation immunity.
Thank you, Gina. Tracee, do you mind taking a moment introducing yourself?
I don't mind. And thank you. Thank you all for having me today. I'm really looking forward to the conversation. My name is Tracee Allen. I am a senior litigation examiner with NAMCO Insurance Company Incorporated, and we are the professional liability carrier for NAMCO and their clients, their partners who are mostly mutual insurance carriers. I did start off in personal lines, but the majority of my career, about 16 years in commercial trucking, and now I do professional liability where I handle directors and officers, insurance companies, professional liability, which is like bad faith, agent, brokers, errors and omissions, employment practices liability. So a lot going on over here. And currently I'm enrolled online with Texas A&M University School of Law. I'm pursuing a master's in legal studies with a concentration in human resources and employment law. So the journey never ends with me.
That's awesome.
Yeah.
Thank you. So with that, let's dive right into our conversation. So first question out of the gate, I'm going to start with you, Tracee. What are the earliest red flags that suggest a claim could escalate towards litigation? And how can an adjuster tailor their approach to de-escalate before it reaches that point?
Sure. Some early flags for me can be, that claimant being hostile on day one. It can be an insured. It doesn't always have to be a claimant. And for all of you, the answers that I give will be from a perspective of a claims adjuster. So just bear with me on that. So, when a claim is accusatory, insulting, demanding, uncooperative, and the worst for me is when they ghost me. They just stop communicating. And of course, this goes for claimant attorneys too. And those attorneys kind of assume you've done something so terribly wrong that they had to be retained in the first place. And so they have no interest in speaking to you. And a lot of them file suit as soon as they're retained. But some things that I do to de-escalate is when I get that person on the phone, I act like I never will talk to them again. So I give all the information I can from them. I ask them several questions, try to get them engaged, educate them about the claims process, give them reasonable expectations of me, the claims process, what to expect, definitely what not to expect. And of course, if someone's yelling at me and they just don't want to listen, I don't match their energy. I'm the professional. So just always keep your cool and engage in your active listening skills, because somewhere in there of all that yelling, there's a problem that you need to solve. And so once they take a breath, you can just repeat their concerns as you heard them and just be prepared to offer them some solutions.
That's awesome. Something that I try to do as a parent constantly with my kids, although it sounds as if you have a lot more success with your claimants than I do with my kids. Thank you for that. Gina, what about you? What are your thoughts on this?
So to Tracee's point, once the lawyer's involved, the dynamic shifts. And so no sooner than we get a first, claim that comes in, the question becomes, in the context of workers' compensation, can we diagnose necessarily why the injured worker retained counsel? Because no matter what state you're in, this injured worker is potentially entitled to statutory benefits, whether it's lost wages or medical care. And sometimes we find that they go to the lawyer specific to the lost wages. Maybe they didn't necessarily get a clear understanding of why they're not being paid. But the big piece for me is when the case comes in, we try to diagnose what that primary issue is. And maybe the other lawyer is charging full speed ahead. I'm going to go to trial. I want to take 5,000 depositions, when really all their client's looking for is a week of benefits. So it's important that, for our claims professionals, that when you retain your lawyer, something has to happen preliminarily. You have to trust the feedback from your lawyer. So if I say, hey, we took a look at the case, here's the relevant case law on this issue, we may have denied those benefits, but now that we take a look at the facts compared to the case law, maybe we're on the losing side of the argument. And I find that lawyers, whether you're on the plaintiff side or defense side, not everybody has the ability to communicate that message, because not every claims professional wants to hear bad news. Sometimes we're telling you, hey, we've got some great news and we have the defensible position, but you've got to trust your lawyer. And I think that's actually oftentimes where a lot of things can get out of hand or off track on the litigation side, because expectations are different. So I may have a client that wants me to tell them what they want to hear. And then I have another client that says, Gina, give me the 360 view so we can actually de-escalate a situation. Maybe if this injured worker gets their benefits, now we can get to the next step and closer to resolution or whatever that might be. And if it's a lawsuit, for example, and the complaint has been filed, now we're looking to see, is there a way for us to dismiss this complaint? Is it a facial problem with the complaint, or is this something we need to look at for a motion for summary judgment to get out of the lawsuit before it actually gets to the jury? So it's really just, as a lawyer, telling your client all of their options, and, for the claims professional to be comfortable and have that, rapport with the attorney to, see that they're trying to be the advocate, whether it's advocate for quick resolution or advocate going to trial.
My apologies. That's terrific. And I want to pick up on a point that you started getting to, because that ties into our next question, which is about communication. Given your experience, Gina, what communication missteps most often trigger the claimants hitting that legal escalation button? And what can both the adjusters and the attorneys do in order to build that culture of clarity and trust that you are referencing?
Right. So, once lawyers are involved, the communication somewhat slows down, because essentially we're having communication between the lawyers, and then for the respective parties, they're communicating with their attorneys. And generally speaking, what we do is, let's just say I recently got a case where even though the injured worker was represented, he still wanted to be able to call, fax, email, and just harass the client. That's the extreme. That's going to be the scenario that Tracee goes, okay, that's a part of the red flags. Why is this person, too involved with this mode of communication when things are actually running according to plan? And then the other scenario, as we mentioned, where maybe the opposing attorney is not responding. So it's important to, if I'm communicating with the other side, to keep that communication going either by email or by cell phone. Many lawyers on the other side have my cell phone, but please know if they abuse the cell phone privilege, I'm not going to, respond to harassment. And generally speaking, folks, behave. But nevertheless, I think that as far as communication with my client, I'll always do your best, obviously, to respond promptly. And if you're not readily available, let someone know when you can get back with them if there's a more in-depth analysis, because we know time is of the essence, right? You might be under a 5-day time window, 14 days, 30 days, 21 days. And, everybody is normally going to have that red hot emergency email before the holidays. But in order to resolve whatever the issue is, we've got to prioritize it based on which emergency is going to come first, and scale it based on whether or not it's, communication from the attorney or, from the injured worker. But it's normally slowed on my end simply because I'm not necessarily calling the injured worker directly. I would have to wait for that deposition.
And I appreciate that. And I really loved a part of what you said. I loved all of what you said, but there was a part that really resonated with me. And that's talking about setting the expectations of communication, because that's where I think leads to a lot of frustration. And when claimants get frustrated, they start getting suey. And I'm a lawyer, so that's a legal term. So of course, but what that really means is when they're not necessarily, obviously they want an answer. They want an answer that they want to hear, but in short of an answer that they want to hear, what we can still provide them is identifying when we're going to get in touch with them and then following up with them accordingly. So what that means is, hey, thank you so much for reaching out. I don't have an answer yet. I'll get back to you in the next 2 days. And if you don't have an answer in the next 2 days, it's okay to reach back out and say, hey, I'm really sorry. I don't have any answer yet. I'm still looking into it, but I haven't forgotten about you. I see you there. I'm going to get back to you in another 2 days, and keep that communication regular and let them know that you haven't forgotten about them. I think that's exceptionally critical. Tracee, what do you think?
Everything you said. But also, so I just think, if failing to communicate at all is can be a downfall that breaks down, just any type of relationship that you may try to establish with a claimant. And as you mentioned, frustration turns to anger. And of course, anger is not productive in a claims environment. But some things to build on a culture of clarity and trust is just to always be honest, even if it's bad news. And my practice is to deliver that bad news as soon as possible. We like to delay bad news and put it off. Oh, I got to call this person today, and I don't feel. Just rip off the Band-Aid, just get over with. Then you can sleep, have a good weekend if you can, but it's just allowing people to make their own decisions based on the information that you give them. And of course, be accessible. Like you said, when we, as claims adjusters, we have to be accessible. We have to return calls, give them your email, give them your phone number. And like you said, have regular follow-ups. And when you do what you say, and they just appreciate that. Even if they're angry with you, at least you may get some level of respect from them. And when you set reasonable expectations for yourself and don't overcommit, then you will be able to manage your desk better, manage your mental health as far as claims environment is concerned, just all around.
That's terrific. And I saw your comment in the chat, Precious. You're absolutely right. Bad news does not taste good cold. You have to serve it up while it's still piping hot. In addition, you need to communicate it broadly. But on top of that, the one thing I would say to the claims professionals on the call, don't forget you have allies. You are not necessarily alone. And sometimes I found it to be impactful that before I deliver the bad news to the claimant, that I'm reaching out to the agent and or the broker to say, hey, here's what I've seen. Here's where I'm going with this. I'm going to reach out to the claimant and let them know, but I just want you to know first and be aware so that you're prepared to communicate a consistent message if and when that claimant reaches out to you, and just sort of building that community based on your position is going to be helpful for you down the road. But with that, I would say let's see if we can shift gears a little bit and talk about some actual claims handling issues when it comes to litigation. Let's start with you, Tracee. How do you think that implicit biases about race, socioeconomic, or anything else impacts claims handling or the defense of claims? And what could we, as enlightened, diverse professionals, do in order to make sure we're influencing a fair outcome?
Yeah, I really appreciate this question. First, I'll give you just kind of like a general response and then a personal response. Implicit biases can impact the claims handling because to some degree we all have them, but whether or not we've worked on them to contain them or manage them so that they don't negatively affect how we treat people, especially when it comes to performing our jobs. So just give you an example, like when we learned, this is like back 20 years ago, might be aging myself, but when we would learn that a claimant came from a particular background, unemployed, low income housing or things like that, but they had an accident, do you just throw them a couple $100, something that they desperately need to make it go away? Well, it's funny because I was joking with a colleague, like back then it was like Oprah, you get $500, you get $500. Like $500 20 years ago was the number that you offered minor injury claims, right? So, but each claimant deserves their own independent, objective valuation of their claim, right? But on a personal note, and with me handling employment liability claims, I knew it would come the day where I would face a claimant who looked just like me and is making allegations that I've actually suffered through. So it's pretty. This particular claim I have is pretty difficult for me. There's a real opportunity there for me to influence the outcome of this case in a fair manner because I have a unique position. I'm the carrier. I'm the adjuster adjusting the claim and ultimately is going to pay the claim. But I also have my insured that I have to look out for, understand why they feel like they need to defend these allegations. But with me being in the room, I think that I could offer some background on, these claims actually may be valid. Just because you don't understand them, they may be valid even though what you've done to make that person feel that way wasn't intentional. We still need to recognize it. So needless to say, I'm just not looking forward to an upcoming mediation we have. Me and the other person are the only people of color, and I'm kind of on both sides. So I think I'll be the most uncomfortable person in the room.
I'm so grateful that you shared that with us because I could tell that it was making you uncomfortable, and it's okay. That's what this group is for. We should be having uncomfortable conversations because you're with your people, your tribe, and that's what we are for you. But I do want to let you know that let's put a pin in that because my next question is going to come back and to push on that a bit more, and I'd love to hear a bit more of your thoughts about that. But before we get there, Gina, what are your thoughts about this?
I agree with Tracee's point specific to objectivity. So you always want to say these facts as to this law, and that's really going to be your litmus test. These facts of this particular case as to this specific body of law. And that objectivity is what allows you to say, regardless of who's on the other side, what am I really doing as far as assessing the exposure? What am I really doing as far as assessing the defenses? Am I assessing the defenses because I don't like this person? Am I assessing this, because of how someone may have behaved in the claim, or maybe that person's character, maybe that person's background? What am I really utilizing as my litmus test? And it's also important as the advocate on behalf of your client, so whether I'm collaborating with an adjuster with the carrier or I'm collaborating with an employer, oftentimes they're leading with what I call the other stuff, right? The non-medical claim drivers. And it's important to identify the other things that are objective, because I've had scenarios where clients want to kind of ride it until the wheels fall off regarding the other factors. And let's just say, prior bad acts, if it's outside of the 10-year window, good luck trying to get that into evidence. Are you really utilizing this information as the reason why you want to deny benefits, or a reason why you want to take something to trial? The facts relevant to the claim, you've got to take that stuff and shake it up, stir it around, and say, this is what we have. So yes, there are other pieces of information or clues that may, from a legal perspective, give you a defensible position. You still want to be objective, because when I go to court, that's what the bench is basically saying in the context of a workers' compensation claim. In the interest of justice, we're going to be fair. We also know that if it's a jury trial, now we're trying to diagnose what's happening with the jury, and are we utilizing our understanding of implicit bias to now determine whether or not we're going to have a juror that is not going to focus on the facts or the objective pieces of information that become available, because we know they're human, right? But in workers' comp, we're going before an administrative law judge, so that judge is going to be my judge and my jury at the same time. And again, optically, we know the judge is going to be looking at the parties and other factors. We want to direct the court's attention to the things that, as a part of that litmus test, Your Honor, it's about these facts, this case law, and nothing more. And that's the important part for us to not only do with the bench, but to also do, when we're dealing with the claims examiner. If I'm giving Tracee a settlement evaluation and I'm telling her what the case law is, she has before her something that's objective, as opposed to me writing her a letter to say this guy is a jerk based on all of these things, let's get him. Like, how is that really going to help her?
That's so insightful. Thank you for that. In terms, from my experience, I when I saw this question, I thought a lot about, unfortunately, some very explicit biases. You mentioned just now, Gina, about juries. I remember when I was being trained as a young associate, and then when I started trying cases, and even as I was an adjuster in the casualty lines, dealing with juries, going to trials, dealing with mock jurors, the attorneys involved were pretty explicit in their biases about the potential jurors that they were looking at. The whole point of jury selection, as I was told, was it's all about stereotypes. And you look at the people based purely on the color of their skin, and you make a tremendous amount of assumptions about them and what they're going to think, and what message is going to resonate with them and what message isn't, and whether or not you want them on your jury. And just based on taking a look at them, and unfortunately just looking at their skin color and understanding their socioeconomic background, I think that does a tremendous disservice to the profession. I think it does a tremendous disservice to the claim itself, because as we all know, stereotypes are not true. They're overgeneralization. So for me, when I was in that position, I would always push everyone to say, let's move beyond the assumption. Let's really start digging into these people and understanding who they are. And that's where jury consultants are extremely helpful, because they're going to be the first ones to tell you, no. You can't look at somebody's face and say, this is how they're going to behave. And instead, jury consultants are going to pull social media information, internet information, publicly available information in order to try to pull together additional information and points of contact so they can understand how somebody's going to behave. Is that perfect? Absolutely not. Is it where we need to be? Of course not. But is it moving in a direction of trying to see people for who they are instead of just assuming that they're going to behave based on their skin color? Yeah, I think it's trending in the better direction. But it just means that there's an opportunity for improvement for all of us, that when we think about claims, when we think about litigation, that we're making sure that the people that we're relying on aren't falling into the traps of these biases, whether they're implicit or sometimes even explicit. But I'm gonna keep a promise that I said. Remember what I said about communication? If you say you're gonna do something, you got to do it. So I'm gonna come back to you, Tracee, with the point that you were raising about dealing with a claim where the person sitting across from you is somebody that you could easily say, "Hey, that could have been me."
Mm.
How do you think empathy and tone shapes actions with policyholders, plaintiffs, opposing counsels, especially when we are dealing with communities of color where their trust in the system is probably already pretty fragile?
Yeah. Well, definitely empathy can go a long way. Without apologizing, you can still express that you understand what a person's going through. A claim is very upsetting, disruptive, it's inconvenient, but what I like to do is ask them, what can I do to help you? And then help me help you, So I tend to just educate them on the process. I like empowering them to be involved, even giving them a little simple task as go get a pen and paper, make sure you have my name, number, way to contact me, write down your questions as they come up, contact me anytime. I want them to know that even though I've made no guarantees of coverage. I'm still investigating the claim. That I still want them to know that they're going to be heard. And a lot of times we don't ask them, have they had a claim before? Like, what are your concerns? And usually you'll find out that their concerns are based on somebody else's bad experience with an insurance company or a claim. So it doesn't matter how much you reassure them, they're going to hold on to those stories from their friends and families. But to me, if you can show that you're trustworthy, then that will go a long way. Oh, you're on mute. You're on mute.
Sorry. I already warned everybody I'm not great with technology. So great point, Tracee. Gina, do you have anything to add to that?
I mean, absolutely. It's Tracee spot on. I think one of the things that was interesting from my days as a claims adjuster, with my typewriter on my desk and my file cabinet next to me, taking my recorded statements and putting them in the little folders. It rings true every time, whether it's the individual's first claim or their fifth claim. There's an expectation there. So we have to figure out, what is driving that claim. Are there other factors? Are there other things to be aware of? And to Tracee's point, you never necessarily want to make a promise on delivery of benefits or coverage or outcomes. But sometimes, so long as people understand what's going on and the reasons behind any type of, decision that is a denial of benefits, oftentimes that goes a long way. And I know as a former claims adjuster myself, you can get extremely busy. And then, of course, now you may be off to the races in litigation. And oftentimes what we see on our side is, we're taking the person's deposition for the first time, and we have to allow them an opportunity to somewhat vent and to, get those concerns out. Now, listen, if I ask you a question, we're going to answer it. We're not going to be here all day. But there is an opportunity for you to, allow them to share, so long as it's not disruptive to the process, because what's going to happen, the judge is going to do the same thing in a comp case. The judge is going to allow them an opportunity to have their day in court.
All right. I see that Gina is frozen momentarily. Hopefully we'll get her back. In the meantime, I will slightly pivot in the Q&A. There was some interest in the Q&A about further discussion about jury selections in general and how we can try to move past the common stereotypes that are built into the system by the attorneys and get to the real heart of the issue. And I think the point that we touched upon before, but let's really be very clear about it, is to make sure that during jury selection, that when we're engaging with the jury, we're not just trying to make them fit into our stereotype about them. Instead, how about doing something really crazy and actually talk about the case itself? Try to start socializing the case and the issues with them and trying to get a feel based on their reaction, how you think they would feel and they would side based on the questions that you're presenting jury selection by just focusing on the actual issue itself. I'm going to turn that over to you, Gina, since you didn't get a chance to finish your last thought, but we're moving on because we have lots of more things we have to get through. But as an attorney, what are your thoughts about that?
I agree. And it's even, the process prior to getting back to the dynamic where it's just the parties, in a mediation setting. Let's make sure that we're allowing both sides to share, to have that communication, because sometimes the other party just wants to be heard. Is it a wrongful death case where the family knows that although they filed the lawsuit that their loved one caused the accident, sometimes they just want to go to a mediation and play a video so you can have an understanding of who that person was and to understand they're using the litigation to get some kind of resolve or feel better about the situation. You have to allow those processes to take place. Am I going to go to a mediation and say, dear grieving mother, your son was intoxicated, your son was driving in the wrong direction that caused this accident? That's really not the time for that, right? We have to incorporate that empathy, because in essence, that's where the mediator comes in later on. But sometimes people just need to be heard. And it's absolutely correct. Fast forward now to the jury selection, it's really paying attention to those questions to make sure, am I actually using what I say to my 6-year-old niece, my listening ears? Because sometimes we just want to hear what it is that we want to hear, because our implicit bias has already programmed us to say, no matter the output, I already know what's going on here. And this question is more of, a transactional formality as opposed to me really processing what's being said to me.
That's terrific. And with that, I'm going to take your last point and I'm going to spin it over to a question for you, Tracee. So get ready. Let's take it out of the jury context and let's put it back into the claims discussion itself and what you do as a claims person. Why is it important to have a set of diverse voices at the claims table? And how does having that representation through diverse voices influence the negotiation strategy as well as credibility in court or any other parts of the claims adjudication litigation process?
Yeah. From a claims perspective, having representation definitely matters, especially when it comes to negotiating a settlement. Defense counsel or whomever you have that's giving you input on evaluating your claim may only consider the things that they see or read, in a record or whatever it may be. But when you have diverse perspectives, you can offer something different, like creative approaches to negotiation, thinking outside the box. If it's someone, again, who looks like you, or even maybe your claims team just don't have a pulse on, what their needs are. Maybe they just never asked them what their needs were. I know that when I was handling claims, if I had like a minor with an injury and it was a single mom, I would offer to have a structured settlement, because to me, it was more important that they at least give them the opportunity to stretch out the money, instead of giving them this 5-6 figure check and then it's gone within a year. So just things like that, looking out for the needs, long-term needs of a person. And that's just one example. And I don't know if I'm telling my age, because I don't even see the structured settlement commercials on TV anymore. Remember, they used to be in heavy rotation.
Yeah.
I don't even see that anymore.
Yeah, what was it, Gigi Wentworth or something? That's the one that I remember
Yes.
the most. That's what happens when you have a catchy jingle. I'm always going to remember it.
Right.
Now let's switch gears a little bit again. I really want to come back and push upon what you were so kind to share with us, Tracee, speaking up from your personal experience. So I'm going to start by going to you, Gina. What's the one case or the one claim that you've had that fundamentally changed how you approach potential litigation? And what did you learn from that experience that you want to share with us here and the next generation of claims and attorneys that are coming through?
I would say for me, it's not necessarily a one case, but it's a type of case. And it is a type of case where the injured worker was the breadwinner. The injured worker was substantially injured and cannot return to any type of gainful employment after the accident. And then the question becomes, do I settle my case and what's next? I'm involved in an organization that allows for scholarship opportunities to either the descendants of those who've been, injured on the job and the injuries resulted in death, or injured workers who are substantially injured and can never return, and their children are looking for scholarship opportunities. Those are the things that, we're never going to be in these claims, making everyone whole. But what can we do that if clients making a recommendation for a doctor, we don't want the doctor that's just going to get in there and say nothing's wrong and keep it moving, because we know the judge is going to have an opportunity to see that. We want the credible doctor. We want the doctor that is fair. We want the doctor that is going to help that injured worker, be as best as they can as far as being whole is concerned. So those are generally the types of claims that, between being a former adjuster and now in my capacity as a lawyer/advocate, what can we do to help this person, in essence, transition back to life, once this claim is over. And there is such a thing as, the injured worker that is now ready to settle the claim.
Okay, I think Gina's tied up again. So we'll come back to her
does
in a
have
moment.
a flow of money on a regular basis. Authority. Yeah, sorry about that.
No, it's okay.
And to the issue of settlement, it's basically just, brokering that deal to make sure that it, long term, that person's going to be taken care of. We don't want to have this mindset where we don't have the empathy and we're not concerned that once we issue that check, what's going to happen next.
That's terrific. I love that answer. And you talked about the injured worker who's being the breadwinner, but in terms of assuming that injured worker had kids, if they're minors, if they're under the age of 18, the probate courts get involved in that to make sure they're protected, correct?
Yes, essentially, they get involved in the process as well. But, in the workers' compensation space, they are statutorily capped benefits. So you're really just assessing dependency and who falls under that criteria. But, if it's a lawsuit, for example, then now we know we have a different, arrangement as far as trying to structure that deal for the benefit of any minor children or dependents.
Terrific. Tracee, do you have a different claim you want to talk about, or are you going to talk about the claim you already referenced?
No, no, I'm not talking about that claim. I mean, when I got that claim, I got kind of emotional because of what's in it. So no, and that, and take my advice, like that is one that I have on my desk that I do try to avoid. I don't avoid it to where I'm not handling the claim. It's just that it's one that's all the way over here. But when I thought about this question, I'm more so thought about, so I handle the majority of my claims is handling insurance company bad faith claims. So, looking back on when I was an adjuster and trying to mitigate our exposures in, when it escalates in the litigation, I think that it is based on investigations, like that initial investigations, your efforts, your diligence, your thoroughness in the beginning of a claim, because I've just never ran into a defense attorney who said, oh, you got too much evidence, you got too many statements, you got too much, you did too much. I've never heard that. So, and that gives them something to work with. So, but a turning point for me early on in my career was that unfortunately a lot of claimants can be untruthful. So I feel like that we need to do our best to always handle our claims in good faith. You document if there's something important that you have discussed with someone, put it in writing. Multiple unanswered phone calls, I put it in writing, hey, you didn't call me back on A, B, and C date, and I need you to call me before this date, and here's your statute of limitations date. I mean, anything that I can show that I have put forth the effort of giving that information to the other person to make decisions, or I have done everything I can to move that claim forward to resolution, I can feel good about that claim. Now, you can't prevent, a claim going into litigation 100% of the time, but what you can ensure to mitigate your exposures is just do what you say you're going to do and follow the guidelines. Don't cut any corners. And that's pretty much it. I just think that always should have a plan. When you pick up the phone call that first day, always have a plan of how you're going to move the claim forward.
That's great. I think you gave us like 7 or 8 great tips there.
Sorry.
I think what you need to do is you need to create one of those paper calendars on a desk that every adjuster can just peel back every day. You have another tip of the day on how to be a really good adjuster. I think that's a multi-million-dollar idea. I want half of everything you make, Tracee, because that was my idea, but you can take it and run with it.
Sure.
But I think that's the next step for you. That's your retirement plan.
Thank you.
For me, the claim that I think about constantly was when I was an excess casualty adjuster, so handling the really big, nasty, multi-million-dollar claims. It was a situation where our truck driver rear-ended a young mother and her, at the time, 6-month-old infant that resulted in catastrophic brain injuries to the infant, who then became, unfortunately, incapacitated for her life and for presumably the rest of her short life. And when I went to mediate that claim, everything that I'd been trained to do from the time I was a defense attorney to the time I was an adjuster was always, that's the enemy on the other side. We don't care about them. We're not thinking about them. They're greedy. All they care about is money. And all we need to do is to try to drive down their number. And that was my mentality going into that mediation. Few hours into the mediation, we got really stuck at a number, and we couldn't break through. So finally, I sat down with the mediator and I said, there has to be a reason why we're stuck. Can we have a heart-to-heart with the claimant, with their attorneys present, my attorneys present, because I want to understand why we are stuck. So the claimant comes into the room. I'm sorry, I'm probably going to tear up because I tear up every time I think about this. It was the dad. And actually, he didn't come to the room. We went into his room. He was physically holding his daughter, who at the time was 5 years old, and he had held her during the entire day's mediation for hours and hours, just holding her in his arms. And I'm sorry, getting emotional. What he said to us was he needed to make sure that whatever we were going to settle the claim with would ensure that his daughter would have a proper sized van so that she could be transported from home to the clinic to wherever else that she needed to go. And he was just so worried that the money we were offering wasn't going to be able to satisfy their continuing need to have new vehicles and have those vehicles upgraded with the right handicap equipment. And that completely changed everything I thought about claims handling and claimants and the other side in general, that I had forgotten that they're humans on the other side with thoughts and needs and wants. And it's incumbent upon us to understand that if we want to get the claim towards its rightful conclusion. And just to wrap up that story in a nice tale, thanks to you, Tracee, had a structure broker with me, and we made sure that create a structure separately just to make sure there was enough money for the rest of this young woman's life, that they would have money in perpetuity for any vehicles, any upgrades and maintenance to those vehicles. So that was something they never had to worry about ever. And the claim settled pretty shortly after that. I always took that away as remembering that it's not just a claim, it's somebody's life at stake oftentimes. And it behooves us as adjusters, as attorneys, as professionals in this industry to never lose sight of that.
Yeah, that's
So
amazing.
with that, I want to turn over to probably our last question for the day. I'm going to start with you, Tracee, and I'll move to you, Gina. if our audience can take just one action after today's session to strengthen their own risk mitigation tactics or to help others do the same, what do you think that action should be?
My motto in life, period, is just to lead with integrity. You have to go into every claims environment, every even personal environment, wherever, just lead with your best foot forward. As far as claims handling, when you lead with good faith intentions, you don't try to sidestep, you don't try to not intentionally mishandle, but if you know that something needs to be done and you didn't want to do it, or someone told you not to do it and you think it needs to be done, then you need to err on the side of doing it, So it's just always try to make those important decisions to put your best foot forward. And because, again, yeah, you're right. The other side, they're human. These are people's lives that we're, they're coming to us, or whether or not it's voluntary or not, in a time in their lives where it's totally disrupted, and it's up to us to have that human interaction with them, even though we have a job to do. So it's about finding that balance, but also if you care about other humans, be human, so that's about it.
That's wonderful. Thank you. Gina, what about you?
Absolutely. I agree. I think whether you've been in the claims space for a week or two, or you've been in claims for many, many decades, we're all going to encounter scenarios that we're not sure, what the right decision is. And I'm a big fan of phone a friend. Maybe you have a colleague that has had a similar case. Maybe, you are ready to make a decision, but it needs a legal opinion, or, maybe you need to roundtable that file internally. I think the big takeaway is phone a friend. Too often I see things once somebody did not phone a friend. And when that ends up happening, we find litigation where it's either a wrong call because of a misunderstanding of the law, or just someone who said, you know what, I'm going to find a reason why I don't want to pay this claim. I just want to deny it and move on to the next one. And, every state is different. So just because you have, experience in the Northeast, that might not be how we do things in the state of Florida. And I have had so many clients get into trouble because they've had experience with other, states. And before you know it, you're off to the races with a lawsuit instead of a workers' comp case because they did not phone a friend. So, just kind of in the bubble of this seminar, whether it's on the claim side or in the litigation side, it's really important that we talk, and that the communication show the 360-degree assessment of any fact pattern, and that you're not just making that good business decision, but you're also making that decision, to Tracee's point, that is fair, and is with integrity, and you are appropriately dispatching your duties under your license to either administer that claim or to represent your client in court.
That's terrific advice from you as well, Gina. Thank you. For me, and this isn't just advice about risk mitigation tactics, it's just about life in general. One of my favorite movies of all time is Pulp Fiction. There's this wonderful scene in that movie where John Travolta is having dinner with Uma Thurman, and Uma Thurman asks him, do you listen or do you wait to talk? And I realized that very early on in both life and in my career, I waited to talk. And I've learned through the years that it is infinitely better in both life, personal and professional, to listen instead. And I found that oftentimes by me not speaking and instead choosing to listen, just as I did today, listening to both Gina and Tracee, I learned a lot and I came out better for it. So if there's anything I could say to this group is let's all keep practicing the art of listening, because sometimes depending on who's speaking, it certainly is an art. With that, I would ask Ashley to come back. As we are wrapping up today's session, I'm checking the Q&A to make sure that there are no more questions there and nothing else in the webinar chat. I hope all of you have found this extremely informative and helpful. It's been illuminating for me. So thank you, Tracee. Thank you, Gina. I've learned from both of you immensely. And with that, Ashley, please go ahead.
Jeff, Gina, Tracee, thank you so much for your expertise and the conversation that you have. The power of clear communications was a theme, is something that I have, and building trust. Your examples were, you were able to break down such complex topics and identifying opportunities and best practices for us, those who may not have your seats but need to understand how the best places for us to work with you all, or how the two seats can work together to help mitigate some of the things that you all talked about. This was an amazing conversation. I'm so grateful that we were able to get you all together and have this conversation.
Thank you for watching this flashback episode of NAAIA. We appreciate your time and hope you found the insights valuable. Stay tuned for more enriching content. Until next time, thank you for being a part of the NAAIA community.